Good evening. This is John Milburn for Laws 12062, Alternative Dispute Resolution. This is week 9. We are a little behind in terms of the content compared to where we should be. This week we're following on from other dispute resolution processes, and last week we introduced the Dispute Resolution Advisor regime. I provided some commentary and invited you to do some research. I've posted on Moodle a series of questions in relation to dispute resolution advisors and other forms of dispute resolution, which, if you've noticed, has a more commercial feel than some of the other dispute resolution procedures that we've discussed in the unit so far. Before I go into that, I'll just mention that I'm well advanced in marking the first assessment. Thank you very much for everyone who has submitted the work. I'm very pleased to say that in relation to this cohort, you are extraordinarily good at submitting your work on time, to the point where I am confident I'll be able to release the marks before the final cut-off date. Usually I have to wait until the Sunday after the cut-off date, but I should be able to release the marks possibly as soon as tomorrow. Overall, the work is good, although I am not, it's hard to get marks out of me. So don't be too optimistic, even though the work generally is very good. Anyway, more of that later next week. So coming back to dispute resolution advisors. Last week I invited you to consider the basis upon which one might consider appointing dispute resolution advisors, the industry, primarily construction, in which it features, and some tips in terms of when you might consider the appointment. Essentially, it would seem to me at a pre-contract stage is a very logical time to consider the appointment of a dispute resolution advisor. The DRA can help the parties even to negotiate the contract for the purchase or be appointed as a result of arrangements within the contract. I think there's a great scope for appointing a dispute resolution advisor as part of the pre-contract stage. Have a look at your commentary for two things. The first is refer reasonably often, I think, to figure 1.1 on page 3 of your text, where, as you'll recall, I've described in the past, we have 14 different types of ADR process described, and you'll see that dispute advisors feature as number 3. So only negotiation and partnering are less formal than a dispute resolution advisor. The dispute resolution advisor commentary is also on page 151. Have a look at 5.1, figure 5.1, which shows a dispute resolution advisor flowchart. Now, it is an example. It was the one used for the refurbishment of the Queen Mary Hospital in Hong Kong, but it gives you a good idea of the process. I invited you to do some online research, and in particular to look at the process adopted through the Australian Competition and Consumer Commission involving the implementation and rollout of the NBN. Now, there is what's called a co-special access undertaking. Now, quick poll, you can use your chat facility or unmute. Did anyone go onto the ACCC website, have a look at the material in relation to dispute resolution arrangements for the NBN? Not a resounding yes. So let's share the screen and we'll look at the website now. Let's hope that we can find the correct one. With luck, what you're now seeing is a web page for the ACCC. Please let me know if that's not correct. And you'll see the commentary relates to the NBN co-special access undertaking. In particular, as far as our involvement in this unit is concerned, look at the dispute resolution arrangements that were dated the 3rd of April 2014. There's a link down the left column and a link under the heading of timeline. If you follow that link, dispute resolution arrangements, it will take you to the approved dispute guidelines document for the NBN. That document provides an excellent template in terms of the way in which the dispute advisor process can be implemented at the contract stage. And also you'll see, if you follow the dispute resolution arrangements, some commentary in relation to the background, why the appointment was made, the basis upon which at law the appointment was made, the purposes that the appointment serves as a purpose, and a list of a pool members for dispute resolution, and some guidelines. Again, have a look at some excellent precedents there to get a real appreciation of the basis upon which the dispute resolution advisors are appointed and their appointment renewed, and the dispute guidelines as earlier indicated. So that's the background material to show, if you like, a real life, very, very substantial real life example of the dispute resolution advisor regime. If there are no questions, I'll keep going, but please feel free to ask questions, unmute your microphone, or use the chat facility in the usual manner. No comments at this stage. And I do thank all of you for joining us tonight in the live session. Now, going beyond that, we move to the dispute review boards. The dispute review boards are number 4 out of 14 on the list of least to most interventionist ADR programs as defined by Spencer. I should say that I agree with almost all of them, but not quite. But I certainly agree with generally the order. This is David Spencer's listing, which I think is very good. It's also, I should indicate that if you have the resources, another book, which I don't prescribe but is very good, by David Spencer, is Dispute Resolution in Australia, which is Cases, Commentaries and Materials. If you're able to access a copy of that, possibly through the library, that could be very useful on this area of practice. Now let's talk about dispute review boards. Does anyone, now I've posted a series of questions so that you could prepare, hopefully, for this evening's session. Would anyone like to tell me where the concept of a dispute review board began? You don't have to be shy. Now, the penalty, of course, for not answering is that you have to listen to me more often. All right, so again, I think it's fair to say that dispute review boards are most commonly found in the construction industry. What's the operation of a dispute review board? What's, if you like, the simple idea, the purpose behind a dispute review board? Any thoughts? Oh, we are quiet tonight, aren't we?
Cost minimisation.
Yes, Nicholas?
Cost minimisation.
Cost minimisation is excellent in a couple of ways. The first is that the cost associated with a dispute is minimised as a result of involvement at an early stage in the process. So therefore, there is not the potential for a huge blowout. And the huge blowout is more likely to create long-term, very expensive problems. Amanda says, quite rightly, to head off problems before they escalate. So that's really the simple idea. So thank you, Nicholas. Thank you, Amanda. So the simple idea, I think, is to keep the lines of communication open, to head off any potential problems that might lead to disputation. So what does it mean? How does it actually operate in practice? Who is this dispute review board? Anyone like to tell me? Is there such a thing as Dispute Review Board Queensland? All right, so essentially it's a panel of experts who are appointed to meet regularly throughout the course of a project, and the purpose is to resolve disputes promptly. Again, if we look at David Spencer's chart, this is one that's at the non-interventionalist process, at the non-interventionalist end. So it's not as formal as some of the other processes. It's a long way, for example, from arbitration. So you get an idea of where this sits. It's not quite negotiation, it's more formal than that, but it's a long way from arbitration. Usually there are 3 people appointed to help to resolve deadlocks. Now, what type of people do you think are likely to be appointed to constitute a dispute review board? Let's say it is 3 people. Any thoughts? What type of qualifications? What type of people? Experts in the field. Yes, absolutely. I think at least one expert in the field. Someone that can speak with authority. Someone that can gauge the extent and nature of the problem quickly and say, that seems right or that doesn't seem right from an expert perspective. Any other?
Legal
Yes, Nicholas?
maybe the other one.
Yeah, I would have thought a legal practitioner as well. So they're probably 2 of the 3 that you'd regularly expect to see. And it may be that when we talk about experts, we're talking about, if you like, on the ground experts, for want of a better term, as opposed to those experts that are associated more with the planning stage, perhaps architects or engineers. So usually 3 people appointed to help with deadlocks and appointed early in the process. Okay, let's assume that we've appointed our dispute review board. We've commenced our, let's say, construction process, and we have a problem. A problem has arisen. What's the practical effect then of invoking the dispute review board to deal with that problem, and to what extent, if at all, are decisions final and binding? Any thoughts?
I think they are final and binding if the parties have agreed beforehand that they'll be final and binding. So it's by consent.
Yes. By consent, generally, technically no, as in if the parties refuse to abide by the terms, they usually can go to litigation, but it would be usual for the parties to accept what the members of the review board have determined. After all, that's the idea. And it works on the basis that a resolution quickly, even though it may not be exactly what you want, is likely to be far better than protracted litigation for the cost and time associated with it. So the type of dispute that we're likely to see are more disputes that are technical nature rather than necessarily legal disputes. But having a lawyer in the process, I think, would assist greatly. So has anyone undertaken any practical research around dispute review boards, particularly in Australia? All good. Well, welcome to B has joined us. Monique has joined us. Thank you for coming along. All right, let's have a look at a website. I'm going to share the screen now, and hopefully, please correct me if I'm wrong, you can see a website for Dispute Resolution Board Foundation. Is that correct? So this is www.drbf.org.au. And I'd encourage you now to look at this website to get a feel for what the Dispute Resolution Board Foundation is all about, its aims, its focus, the type of projects where it is involved, the benefits, and some of the successful outcomes. So that's www.drbf.org.au. Let's think about from a perspective of the assessment that you might get for the final take-home. you may have a scenario where you're invited to advise, for example, a construction company in relation to an appropriate manner of resolving disputes. And you may be given a very broad brush in terms of the options that are available to you. So it may be that you encourage your client to undertake some work pre-contract, pre-engagement as a dispute avoidance process, or it may be that you advise your client in relation to dispute resolution processes as we more typically think of them. And then it's a question of how far along the continuum do you go? Do you recommend that your client proceed on the basis that it engages a dispute resolution board? And if so, to what extent? Do you want that board to make decisions? How does it make its decisions? Who's appointed? And to what extent, if at all, is it going to be binding on the parties? Do you want the parties to have the ability to litigate, arbitrate? Are you going to ask the parties to undertake some form of mandatory mediation or conciliation? Will you consider expert determination, early neutral evaluation, etc.? So that's the sort of thing that you might expect. I'm not saying that is it, but let's say it's one of 3 areas, let's say, that might be on the take-home exam. So it's important that you get a feel for it now. Don't leave it for the 24 hours or so that you've got for the take-home exam. It's too late to do your research then. So just get a feel for what these appointments are all about. And as you're doing that, I want you to be thinking about the take-home exam and thinking about how you would proactively invoke these procedures if you were the advisor. So have a look at the Dispute Resolution Board Foundation, and you'll see that it was founded in 1996. It has members in Australia. So here's a tip. At the pre-contract stage, in my view, in a commercial situation, the parties should consider how to operate in practice. For example, what are their disclosure obligations in the event of something going wrong? Are you going to mandate in the documentation that there is, if you like, almost a fiduciary duty to make disclosure of issues that may be of concern? The idea being that you don't want parties to cover their tracks and hide something. You want the parties to have a positive obligation to disclose matters that may be of concern to others or that may jeopardise the entire project. And once you invoke this procedure, how's it actually going to work? Now, we've said that there might be a number of people appointed, but I mean, are the parties going to be summoned, if you like? Are they going to be subject to cross-examination? Are you going to let the lawyers in? Are the lawyers going to be involved in the process of making submissions and preparing documents? And it may be that there's not necessarily a right or wrong answer here, but it's for you to be creative in terms of dispute resolution to come up with an appropriate model to meet the circumstances. Have a look at another one. If there's any questions, please stop me or just unmute the microphones. Partnering. Now, where does partnering sit on the continuum? Can you give me a number, 1 to 14? I think you know what I mean by the continuum now. I'll give you a hint. Negotiation is number 1. Arbitration is number 14. Where's partnering?
Number 2, isn't it?
Number 2, yes. Chris, Amanda, and Nicholas, all almost exactly at the same time. So number 2. So it's not what we'd call a dispute resolution procedure per se. It's more a dispute avoidance process. It's less formal than even a dispute resolution board. And it is, if you like, a form of do-it-yourself dispute avoidance process or ADR process. Now, as the name implies, the process is designed far more at avoiding a conflict than dealing with a problem after the event. So therefore, it is entirely appropriate to consider it at a pre-contract level. In fact, I think it's almost mandatory to consider partnering in the context of commercial disputes at that early stage. What's the idea then of partnering? What does it actually mean? So the question that I gave in the homework assignment was, number one, describe the operation of partnering. Does anyone want to tell me what partnering actually means? How does it work in process, in practice? I think we've all been doing assessment number one, and we're only now starting to think about the take-home exam. So when we talk about partnering, we're really looking to take advantage of an in-house advisor with technical skills. And the thing about partnering is that the parties develop what's called a charter. It's, want of a better term, it's a sophisticated handshake. So it's not intended to be binding, but the parties develop a charter, if you like, a code of conduct. It relies on a lot of goodwill, cooperation, transparency, honesty, and a willingness to accept if you've done something wrong, to accept and put your hand up straight away, to take advantage of the process and deal with it. It's particularly relevant for technical skills. Now, as we speak, you might be thinking, in what type of industries could we involve ourselves in this partnering process? The second question in the homework is, who are the stakeholders in partnering? And where would it fit in? To have an in-house advisor with technical skills have some role which is subject to a charter between the parties where they have this sophisticated handshake. If you like, it's where the parties adopt a cooperative culture of mutual trust. So that's very important. And really, I think these three that we've discussed so far this evening are all involved in cooperative process, and it's developing a mindset that is non-adversarial, it's cooperative in nature, and it very much does rely on mutual trust and mutual obligations. So in partnering, we specifically have this thing called a charter. Now, what's the process for partnering? Let's be specific about it. What do the parties actually do? We have an expert with technical skills. We have a charter. We have a culture of mutual trust, honesty, and transparency. Beyond that, let's talk about the operation. It's in two parts. The first part is that the participants undertake a workshop. So you build this into your process. Before you even start the project, you have a workshop. 6 things. You set up an agenda. You find a location. You find a leader or facilitator of the workshop. You use some team building exercises. You identify the interests of the parties, and you identify the issues of concern and the likely means of resolving the issues. Now, it might seem a bit airy-fairy, for want of a better term. It might seem a bit academic, team building, workshops, non-lawyer-like in terms of its outlook. But you get the idea that the workshop is a formal process that introduces partnering, it introduces the players, if you like, and it builds the culture that leads to successful partnering. But it's built around a charter. So number one is the workshop, number 2 is the charter. In the charter, you identify a mission statement. Many organisations have mission statements. So the idea of partnering is that it has its own mission statement built into its charter. But more than that, the charter sets out the ground rules for communication. There are statements about review and reinforcement of the charter, and a process built in to review the process and review the charter. So the idea is that participants are aware of this document, they commit to the document, and they work towards the overall goals. So the stakeholders in partnering, again, most likely used in construction industry. Used properly, it can significantly improve performance. But there is, in my view, no reason why it shouldn't be worked in beyond the construction industry. I think it can be used in other industries. Yes, B?
Yeah, I was reading up about this and I came across one of these documents that talked about the NBN code, Special Access Undertaking. Is that an example? Because they got all these NBN providers do that. And
yes, look, they're very close. We actually dealt with that just before you arrived under the heading of dispute advisors, dispute resolution advisors. Yes, but that was the NBN process through the ACCC. So that's along the same lines, but partnering is slightly different. Partnering is even more, even less interventionist than that.
John, was partnering
Nicholas?
part of the application used in Hong Kong for the development of that major medical centre? Was they used partnering in that scenario?
Sorry, yes, they did, but it was more, again, dispute resolution board process used in that one, or dispute resolution advisor rather, for the Hong Kong, the refurbishment of the Queen Mary Hospital. So have a look at Spencer on page 151, figure 5.1. And again, these concepts are fairly close, but that was under the heading, the formal heading of dispute resolution advisor. And I'm very aware that sometimes you might have the same thing, but call it one or two different things because they're very close. But thank you, Nicholas. Thank you, B. Amanda says, would you use it in joint ventures, mergers and acquisitions? I think so. I think mergers and acquisitions could be a very useful area for the use of partnering. And it could be something in the, I don't know, I think in terms of industries that are involved in charities. So it might be even church-based organisations or other enterprises where there's an expectation of a lot of cooperative practice. So partnering, maybe even law firms could use partnering. Yes.
yeah, I think I can think of one, because I just remembered where I heard it, like these firms like KPMG, they offer some kind of project thing where they partner, like I think where I'm working, they're coming to improve our efficiency. So they've got all these things, they've got all these stakeholders coming together, and then they're setting out confidence building, they're developing shared goals, and they're trying to change the processes of how we run things to make it more efficient.
That sounds very much along the lines of what we've been discussing in the context of partnering. So subject to any confidentiality issues that may arise, B, please feel free to share that through UCRU or others that may have come across instances of what we're now describing as partnering. Or if you think of a scenario where you believe partnering may be efficient way to resolve issues, please share that with us. So the two questions for partnering: what's the operation? We've discussed that. Who are the stakeholders? Well, we've kind of identified that, and it's particularly useful where there's some degree of complexity in relationships. So I've said it can work beyond the construction industry. There's no reason why it can't. But if you have a degree of complexity in relationships, multiple parties, potential for breakdown in communication, that's the sort of thing where partnering could be very useful. All right, so let's think about some tips in the context of the philosophy of partnering. Now, properly implemented, it identifies a collective goal rather than potentially competing individual goals. So you see the difference? One group within the overall project may be focused on what it does and it does alone, whereas the idea of partnering is to broaden the horizon and adopt, if you like, a we approach rather than a them and us. So if you feel that there's potential for a them and us within the context of a project, then maybe we need partnering so that we have a we culture. Now I know, again, I apologise, this doesn't sound very lawyerly because lawyers traditionally, we like to litigate, but this is part of the new process for lawyers to become familiar with. So if you were dealing with a client who was involved as a stakeholder, or if you like, the principal stakeholder in a project, you might want to speak with them about partnering. And it might be a matter of finding out what are the ambitions. Is it to make a profit? Is it to complete the task safely, quickly? Are they worried about reputation? Is time a factor? So all of these things are important. So what are the emphasis in partnering? Well, you're trying to work together, mutual respect, flexibility, but very importantly, with all of these at this upper end, is honesty, open awareness and transparency. So you're looking to identify the issues that may arise. You're trying to build a team approach. You're trying to establish good communication networks and then implement it as part of the partnering process. All good? Any questions? All right, well, I'll move on then.
Sorry,
Yes.
John.
No, you're right. Yes, Monique?
Apologies, I was late. It's at another shoot. But just to get a little more context on partnering, and I may have missed it, is it more of a preemptive or proactive approach to dispute resolution than reactive? Is that right?
Absolutely.
Thanks.
And I'll put partnering, dispute resolution advisor, and dispute review boards in the dispute avoidance process category rather than the dispute resolution process. I know we're talking ADR, but it gives you an idea. All right, so now let's go and look at the other end of the spectrum. So again, looking at Spencer's graph, 1 to 14, first, case appraisal. Where does case appraisal sit in? All right. 9, yes. Then expert determination and early neutral evaluation. We'll deal with those 3, which are 9, 10, and I think 11 out of 14. So these processes are all quite similar. And if you'd like, they're similar in the same way that dispute resolution advisors, dispute resolution boards, and partnering are similar, but they're at the opposite spectrum. So they're ADR processes, they're very similar, and they are essentially more aligned with adjudication rather than consensual process. Now the terms case appraisal, expert determination, and early neutral evaluation are used somewhat interchangeably. So again, this is a new field. So we're still, working on some of the terminology in the same way that a form of mediation can sometimes look very close to conciliation, if you understand what I mean, if it's an interventionist mediation process. So case appraisal, expert determination, early neutral evaluation, all fairly similar, sometimes interchangeable almost. And the terms are not used uniformly, so that can add some confusion. Now, some of these have statutory force. Let's deal with case or expert appraisal. It is an alternative dispute resolution process. It's generally not binding, or in the case of court-ordered case appraisal, conditionally binding. It's undertaken by an expert in industry. It's relatively informal. There are no rules of natural justice, no need for a written reason, and the appraiser suggests a desirable outcome to the parties who are free to accept it or reject it. So when you look at that, you might think, well, gee, that's pretty close to even partnering, or it's pretty close to a dispute advisor, but it's at the other end of, it's on the other side of mediation and conciliation. So think of it in those terms. But it's pretty close to an adjudication. Early determination is again an ADR process. This time it is binding. Why it's a little more formal. It's undertaken by an industry expert, the same as the case appraisal. But it's relatively informal. It's not governed by legislation. And again, there are no rules of natural justice, no need, for example, for a written decision, and the reason and the decision remains private. But it is binding. Then we look at early neutral evaluation, which is now the next closest to mini trial. It is an ADR process. It's binding, but only binding in relation to findings of key issues in dispute. And it's usually undertaken by an expert, by a lawyer. It's relatively informal. And again, there are no rules of natural justice and the decision remains private. So the idea of this process, early neutral evaluation, is that the professional who is the practitioner makes a determination on key issues in dispute, and it's an effective way of resolving dispute without determining the facts of the dispute. Now, when we look at those three, case appraisal or expert appraisal, expert determination and evaluation, I've listed some questions for you to consider. Number one, describe the operation. Two, are they binding or not binding, and what are the differences? So again, if you're looking for definitions, it's always pretty safe to go with NADRAC. And I think that the definition's in the text, but I'll also refer to some legislation. So firstly, the case appraisal, according to NADRAC, is a process in which the dispute resolution practitioner, that is the case appraiser, investigates the dispute, provides advice on possible and desirable outcomes, and the means by which they can be achieved, but it's almost the same as early neutral evaluation. Now, in terms of statutes, have a look at Section 46 of the Civil Proceedings Act. Provides that a court may subpoena a person to attend a case appraisal. It's Civil Proceedings Act 2011. Expert appraisal is a process in which the practitioner, based on their knowledge or experience, investigates a dispute and then again provides advice. And NADRAC describe expert determination in this manner. Expert determination is a process where the participants present arguments and evidence, so it's a little more formal, before a dispute resolution practitioner who's chosen on the basis of specialist qualification, and that practitioner as an expert makes a determination. All right. What I might do is give you a case example. Have a look at IPOH IPO against TPS property number 2, 2004 NSWSC 289. And this case involved a breach of contract. An expert determination clause was built into the contract, and there was power to stay the proceedings was part of the issue before the court. The court at 91 said, clause 21.2 of the agreement, which provided for the determination, said, determination will be final and binding. Clause 39.6 said, the determination will be binding and binding unless the party gives notice of its intention to initiate proceedings. And that was applied in Mineral Resources in Pilbara Minerals, 2016 WASC 338. So that's Mineral Resources against Pilbara, 2016 WASC 338, where at paragraph 103 the court said, I acknowledge the desire for a company to have its day in court, but it bargained away that right in favour of the finality of an expert determination. So when we're talking about whether it's binding or non-binding, the courts will say, in appropriate circumstances, if we look at IPO's case and we look at Mineral Resources case, that it is possible for the parties to contract away their right to a day in court. And that's by reference to case expert determination. All right, so a couple of cases for you there to consider.
Sorry,
Yes,
John,
Kimberly?
just out of interest's sake, if a matter had been determined, gone through the expert determination process and then perhaps brought before the courts, as in your examples, could a party allege that the expert was biased in some way, and then would that be a way to overturn a decision?
Yes. I think that that's always an argument that's available. If even though the rules of natural justice don't apply, there's got to be some accountability. There has to be, you know, if it's clear that the expert was biased or chose not to consider relevant expert or evidence, then I think that's always a ground for going to court.
Okay,
but
thanks.
the threshold is no. You'll need to overcome that threshold.
Sure, thanks.
All right, so again, in the context of the take-home exam, it's unlikely that I'll give you a question about something looking back. It's more likely that the question will be forward-looking in its approach. And so you'll need to consider whether you're going to recommend the parties engage in this process when they're at the negotiation stage, rather than dealing with the issue that has arisen, if that makes sense. Now, I mentioned the Civil Proceedings Act 2011. Have a look at section 41 that deals with case appraisal. If you've got that there, have a look at it. Case appraisal is it defines it. Case appraisal, it's a process under the rules in which a case appraiser provisionally decides a dispute. It's not binding on the parties until the time prescribed for the rules for filing an election goes to trial or has gone by, and or a court gives an order to that effect. So when I say it's may be binding, may not be binding, it means about looking at the contract, but also considering the statute, considering the legislation. Section 45 goes further and talks about a procedure at case appraisal and talks about how that is implemented. Now, I mentioned earlier that it can be confusing here because sometimes these terms overlap and there's no uniformity. So the definition of case appraisal in section 41 is very similar to neutral evaluation or expert determination. There is an overlap, and I do apologise for that. So if you're the sort of student that likes to have everything completely pigeonholed and know this is one, this is the other, I can't promise you that within the context of this area. It's still too new. We still haven't quite worked it out. I hope that makes sense. All right, but you do need to consider the Civil Proceedings Act and have a look at sections 41, 45, have a look at section 43 also. Beyond that, you need to consider the UCPR. Margin for error, yep. UCPR 1999 Queensland refer to rules 334 to 345, which all relate to case appraisal. So if you have a question in the take-home exam that deals with case appraisal, I would expect you to be able to refer to some case law, some statutes, and some regulations, in particular the UCPR. All right, so 334 deals with referral of a dispute to appointed case appraisers and goes on to deal with issues to do with costs, obtaining a case appraiser certificate, etc. Now again, back to statute, have a look at section 53 of the Civil Proceedings Act, which deals with the issue of confidentiality in case appraisal. Section 53 deals with the issue of evidence from the ADR process, when it is confidential, when it can be admitted, when it's not admissible. All right, so let's have a look at some tips then. You're in a situation where you're asked to consider the possibility of having the parties contract to engage, should the need arise, in expert appraisal, expert determination, or neutral evaluation. What are the things to consider? Well, number one, and I'll give you 7. Number one, like many forms of ADR, these options, appraisal, determination, or evaluation, provide informal and effective means of resolving disputes. And I should say that this material is sourced from this text that I raised before. Number 2, the form of ADR is particularly useful where the dispute relates to a specific technical character or a dispute of a specialised kind. Number 3, it applies in particular where the parties can determine the procedures. So again, it is forward-looking. Number 4, the parties can determine the extent to which they choose to be bound, subject to the case law, subject to the legislation, subject to the regulations. Number 6, even if the matter is not resolved, the process can identify issues for determination, and the parties can identify the facts agreed on the facts in dispute, coming back to my next issue. And number 7, and this is important, not only does it save costs, but it also promotes the ongoing commercial relationships. We're not throwing everything out. So there's a lot of similarities between, on the one hand, partnering dispute advisors and dispute review boards that we talked about early in tonight's session, with those at the other end of the spectrum, which deal with expert appraisal, determination, and evaluation. Because the commonality is that I'm encouraging you to think about these mechanisms at an early stage, pre-dispute stage, even though the first lot are really dispute avoidance processes and the second lot are really dispute resolution processes. I hope that makes some sense. And don't be too bogged down on the terminology, and just be prepared to accept that sometimes there will be an overlap. So if it seems to be confusing, just go with it. Don't be too hung up about it. Any questions so far? All good?
So,
Yes,
just
B?
now, were you talking about the expert determination or appraisal? I keep getting the two a bit mixed up, whether you were talking about which one.
They're very close. For example, if you look at the legislation section 41 of the Civil Proceedings Act, it's headed case appraisal. But when you look at the definition in the Act, it's very similar to the definition by NADRAC in terms of neutral evaluation or even expert determination. So the reason I've lumped them together is to acknowledge that there is an overlap to the point where it's very difficult to necessarily define one against the other. But during your reading, when you're reading the cases, when you're reading the material, you may identify some points of differentiation sufficient for you to say, this is the appropriate mechanism. I hope that answers your question, B.
Okay. Yeah, it's just that they seem to be almost the same. At some point, I don't know whether you're talking about this one, and then it's gone to that one, or it's. I know. I
I
looked up.
agree. I
Yeah,
agree.
the EPO case was expert determination, the power to stay proceedings until they complied with the expert determination clause. I think. Yeah.
Yep, very close. Very close indeed. So that was the EPO case. And then we have the mineral resources case, where they're also talking about determination. But it does look, it could easily read as appraisal. I appreciate that. All right. So,
Sorry, John.
yes, Monique.
A little off topic, but I'm wondering whether you have provided or will provide any guidance on how many questions will be in the final paper. I have read the ones that you've already posted for the past papers.
Oh,
But they're
okay.
quite different. All of
They're
them are
very
quite
different.
different.
They're
Yeah.
all different. Yes. Next week is week 10. That's when I'm required to provide you with some advice, and that's what I'll do. But I'll indicate that it's at this stage I haven't quite formalised it, but it's likely that I will. That is the advice that I'll give you. It's likely that I'll give you advice that it's one of 3 primary areas. I can tell you this is one of them. So this whole area of looking at the potential dispute that might arise in, if you like, a big project or a substantial type project. Which one would you recommend and why, and how would you implement it? That's probably going to be one of them, if that makes sense. Okay. All right. So just briefly then, court-appointed referees. We call that referencing out. This is 13 out of 14. It's right next to arbitration. It's undertaken typically by the court as part of litigation. Now, the parties may agree or challenge some of the findings made by the referee. The court may adopt, vary or reject a referee's report, and there is material about referencing out in both the UCPR and the Civil Proceedings Act. The idea is that a court will reference out a question to be determined. There will be a finding of fact, a report that comes back to the court. The court can adopt it, it can reject it, or it can vary the report. But it's, if you like, the court having an opportunity to obtain its own expert evidence. So the questions that I provided in the homework were, why would a court choose to reference out? Is the court bound by the decision of the referee? And what is the legislative basis for appointment of a referee? So at any stage of court proceedings, other than matters to be tried by a jury, the court may make orders for referencing out to a referee appointed by the court for making inquiries and providing this report. The report and any conclusions in the report are of no legal consequence until adopted by the court. The legislative basis, have a look at the UCPR, rules 501 to 506, which talks about referee and referencing out. Finally, adjudication at the very end, typically undertaken by accredited experts in the industry. The BSIPA Act, the Building and Construction Industry Payments Act 2004, is a prime example. QCAT has quite a few adjudicators that make decisions. There are powers conferred by legislation for adjudication. Adjudication is also very substantial in body corporate disputes. Now, it's a more formal process in conciliation. The adjudicator makes a decision, and it's very court-like. It's almost arbitration in its scope. For further information about adjudication, and I'm very conscious of the time, have a look at the Body Corporate and Community Management Act 1997. And in the context of building disputes, have a look at the websites for the QBCC, the Queensland Building and Construction Commission, and QCAT, the Queensland Civil and Administrative Tribunal. And you'll see that there's reference there in terms of payment claims in particular and the role of adjudicators. Well, I'm going to leave it there tonight, and next week I want to start by talking about the criminal justice system, an overview of how criminal justice can be administered through ADR process. It's a relatively new scheme, and it's one I've had the privilege of being a mediator in a criminal dispute resolution matter. Quite different. So that's where we'll start from next week. Have a look at any material to do with criminal justice systems, restorative justice, meaning and in practice. All right, any questions? And you've been very patient listening to me all evening. And just to confirm, with any luck, I'll have some results for the first assessment out tomorrow. All good? Okay. All right. Thank you for your patience. We'll see you next week. All the best. Bye then.